So I'd like to introduce Ashley Bargenquast, who is the CCCBA Criminal Law Section Leader, and she will take us into the program today.
Thank you so much, Anne. As Anne just said, my name is Ashley Bargenquast. I'm the Contra Costa County Criminal Law Section leader of this, and I am so excited to introduce prosecutor-initiated resentencing. We have two individuals with us today who are going to be presenting this and taking the lead. We have Andrea Crider, who is a deputy public defender at Contra Costa Public Defender Office. She is currently leading the resentencing pilot program in the post-conviction unit, advocating for resentencing and release of those serving inequitable sentences in CDCR. Andrea earned her BA in Political Science and History from UC Santa Barbara in 2009 and her JD from American University Washington College of Law in 2016, where she graduated cum laude. Prior to her current role, she worked as a re-entry attorney at Bay Area Legal Aid, where she provided re-entry civil legal services to justice-affected and formerly incarcerated individuals to address legal issues stemming from prior criminal system involvement, and as a deputy public defender at the Solano County Public Defender's Office. She was recently recognized as the Contra Costa County Bar Association's Pro Bono Honor Roll after serving as a volunteer attorney For the People, a nonprofit that works to identify individuals for prosecutor-initiated resentencing. You can find her full bio on this event on the website, Contra Costa County Bar Association. Our other lead on this event is our prosecutor, Caleb Webster, Deputy District Attorney with the Contra Costa County District Attorney's Office. He's been with the office for nearly a decade and has spent time in the misdemeanor trial team, felony trial team, calendar, and workers' compensation insurance fraud units. He acted as the Richmond misdemeanor team supervisor before moving to his current assignment in the law and motion unit, where, among other things, he oversees post-conviction under Penal Code sections 1170.03, 1171.1, and 1473.7. Now with that, I'm going to turn it over to Andrea and Caleb, and they'll take this away. I'm really looking forward to it. The only other thing to keep an eye out for is that the criminal law section will be presenting two different panels, or rather co-sponsoring two different panels at the MCLE Spectacular on November 18th. At 10:30, an employee's response to the Dobbs decision with crossover with criminal, and then at 2 o'clock, You Said What? In overlapping evidence in family and criminal law. Thank you so much, Andrea and Caleb, and I'll turn it over now.
Thank you so much, Ashley. My name is Andrea Crider, and I'm honored to be presenting this project with Caleb Webster. If you want to introduce yourself, Caleb.
Hi, everybody. Yeah, it's really nice to be here, and I think, as you'll see during the presentation, this is a pretty interesting way that to have criminal justice work out, in that Andrea and I are pretty collaborative throughout this process. So a lot of what we do at the PD and DA's offices are fairly antagonistic, or we're at least on sort of different sides. And in this area, at least, there's a lot of collaboration and common ground. And so it's been pretty fun to be a part of. And I hope that you all enjoy hearing a little bit about it.
Yes, great. So we're here to present on prosecutor-initiated resentencing. And until recently, California was home to one of the largest prison populations in the United States. Many of the people are disproportionately people of color, serving excessively long sentences, and they can be released without posing a threat to public safety. And so in comes prosecutor-initiated resentencing, which is a groundbreaking tool to directly and immediately redress the harm caused by mass incarceration and excessive sentences. This allows DAs the ability to take a second look at past sentences that may no longer be in the interest of justice, and ask the court to recall and resentence the people for credit for time served.
So I think what we're going to go over today is just a very brief shot of the history of prosecutor-initiated resentencing, both in California and in Contra Costa. I'm going to talk a little bit about what considerations our office has when we start to look at people who might be eligible for resentencing or might be good candidates for resentencing. And then we'll talk about that collaborative process of the case workup, and particularly what Andrea and other advocates are doing to try to present cases to the committee that makes the decisions, as you'll hear about. And then I know Andrea's going to tell you a little bit more about the law, and then we'll kind of go over some of the different ways that maybe if while you're hearing all this, it sparks in your mind someone who you think might be a candidate for this kind of relief, or that you have additional ideas how you can kind of send those to us, or how you can help participate in this pretty cool process. So as far as questions, I think that we had thought that it makes the most sense for you to just put those in the chat, and then if it makes sense to answer those along the way, we can try to do that. Or if we have time at the end, we'll answer what's left. So the history of this is that, and you've already maybe heard that the group For the People that Andrea was working with before, For the People, it has been kind of at the forefront of this. Hillary Blount was one of the people who really drove some of this reform all along the way from 2018 and beyond. So in 2018, AB 1812 was passed, and part of what the bill allowed is for prosecutors' offices and some other entities. We're focused today on the prosecutors' offices, but also CDCR, Sheriff's Department, and the court with limited range can bring individuals back to the court for resentencing to a term not to exceed the original term. And so that kind of opened up the door for prosecutors to go back and look at cases where maybe the interests of justice are no longer served by the sentence that was imposed previously. Okay, and I'm seeing in the chat that already maybe I stepped on something. So certainly I want to recognize the humanity of the people who are involved. And if I use the term inmates, I will try to work on that. Sometimes those things are ingrained, but I agree. Incarcerated people are the ones that we're talking about in terms of the law here. So then later on, as the law developed, in 2019, then the law went into effect. I believe our office began being involved in the process. I think maybe 2020 is when our office first started to take a look at some of these cases that were being presented. And then the law was further overhauled, and as of January 2022, there's now a stronger presumption towards resentencing when certain cases are brought forward. And our office has devoted resources to looking at these cases, and our office has become one of the founding members, or one of the founding recipients of the pilot program funding. And so there's now a 3-year pilot program throughout California. There were 9 counties that were selected, and Contra Costa was one of those. And as a part of that, we receive a total across the county over 3 years, $18 million. So our county got a portion of that we can put towards this. And that funding goes towards my office, towards public defender's office, and it also goes towards a community partner in the process. So we are continuing to sort of work this out since we're on very sort of new ground. We have to date sentenced 10 incarcerated people over the course of the last approximately a year and a half. We have numerous other people that are before us for further review, and Andrea and I have been working on a process to try to expedite that review in a way that is fair to individuals who are being considered, as well as fair to people who would like to have their cases be considered, but are waiting for us to get through the ones we're currently considering. So I think that gives a little bit of the history. I came into my role as part of the grant funded work as the prosecutor assigned to this in October of last year. So there's been a little bit of a learning curve for me to get up to speed on how we do these things. And then our process is that we actually, I'll wait on the process part. So maybe I'll
Yeah, I can talk about the legislative findings and just the history that I've been in this position since January as a partner with Mr. Webster. I just mentioned some of the really important legislative findings in passing the most recent AB 1540 bill, and wanted to just note that PIR is such an incredibly important tool for us to bring people home. I think they found that as many as 26,000 people can be safely released back into communities, which would reunite families and reinvest that money into drug treatment, mental health care, victim services, and other crime reducing interventions as well. Also want to make sure to highlight why this work is important and what we've come to know within the research, and that is that lengthy sentences and high rates of incarceration have diminishing returns and actually reducing crime rates, and that there's almost no evidence that these long sentences deter the crimes that they are intended to. So that's part of why it's important that we look back at these cases. Many of our cases are over 20 years old. And we have a list of people we are currently trying to get through who their office is considering. And we're hoping to try to increase our numbers over the period of this pilot program to show the success of how important this work is. And I think Caleb mentioned this briefly, but just because this is a CLE, I want to make sure I'm going through all the law and different possibilities. This program will mainly focus on the district attorney's ability to refer these cases, but CDCR also refers cases under the same penal code statute, which is 1172.1. And you can also have recommendations from the Board of Parole Hearings, the Attorney General, and the sheriff. However, I haven't seen those take place at this time. And then I did put public defender invitation, because essentially that is what we're doing when I talk about doing a case workup and referring a case. We're essentially inviting the district attorney to make that recommendation to a judge to recall the case. And from what I've heard, that, you know, it's possible to, the CDCR doesn't take invitations really from the public, but I have heard that they have taken recommendations from these other entities as well as judges past the 120 days. So there are other possibilities of ways to get recommendations through 1172.1. But again, this program will focus on specifically the Contra Costa District Attorney's Office. So with that, I will give it over to Caleb to explain what the current criteria is for considering cases.
Yeah, so our office has, and this predates my turn here, but our office established certain criteria of the types of cases that we wanted to emphasize or put as the initial review. And this list is meant to, or this criteria is meant to be adaptable and to expand over time. But essentially, what we are focused on is looking at someone who was given a long, lengthy prison sentence, has already served a substantial amount of that time. So the ballpark is initial sentence of 20 years or more, and having served 10 years or more of that sentence by the time that we're reviewing the case or close to that. We are not doing review at the time for people who have served a strike offense, with the exception of residential burglaries and robberies. And there are, as you see there, there's some carve outs to that. I will say there's a little bit of wiggle room on these categories that we have looked at individuals who were older than 25 at the time at the time of their robbery, or the time of the robbery that they committed, and were sentenced on, or people who maybe have served a little under 10 years. I know that prior to my time in the unit that someone was resentenced who hadn't quite reached the 10 years. So it's a fairly restrictive list, but it is meant to expand over time. And the hope was to look for some people who would, I think the hope is both that they would do well upon release into the community, and also that we can look back and say, is this a just sentence now from our perspective here in 2022? It may have seemed to be a fair sentence at the time that it was imposed, but now with some extra hindsight and some other things, maybe it's not. Or maybe someone has performed really, really well while incarcerated, and we also want to see this as something that would be an encouragement for people who maybe are faced with a pretty dire situation of being incarcerated for a long period of time. And we understand that that can come with a sort of a loss of hope. So we thought that this program can also be a way of giving people hope and giving people the right to earn resentencing. So then if you want to go to the next slide, we have the pleasure of having Mr. Harbands, David, here today.
I'm just trying to figure out how he can start his video and mic.
Okay. Well,
There he is.
hi, David.
Hey, how you guys doing?
Good. So let me just, I'm going to turn it over to you in a minute, but let me just tell the audience how we sort of came to first consider your case. So we receive a bunch of different we receive names of individuals through a bunch of different avenues. And one of those is through the individuals themselves. We receive a fair amount of pro per mail. And there are a lot of people who have heard about the program or have received information from various sources while they're incarcerated, and then they reach out and ask us if their case might be one that we would consider. So our office received David's letter, and even though I believe, David, you were 25 or 26 around the time that some of these happened, so you weren't under 25, but you were 25, and you received a sentence that was 107 years to life for 4 robberies that occurred in the 90s. And so that, to me, it came into the pile of cases that warranted a little bit more review. So at this point, I just have a letter. I don't have a person's face. I don't have very much, but I see that it meets at least some of the bare minimum to start working up the case. And so we begin to sort of look at some of the underlying offenses and what was involved. And that involves ordering up our files. Sometimes we don't have our file anymore. So it involves ordering up the court file and trying to gather what information we can from there. So as I read your case, David, I thought that it at least warranted closer review to see how you were performing while incarcerated. And so Andrea and I think were working together, and we were able to get some information from your prison file, which is also called a C file. And one of the things that stood out to me was that you had a prior denial of parole, but the parole board had seemed like they were pretty close. They had some praise to give you, but had a couple of areas of concern. And so when I looked at some of your programming, when I looked at the fact that you had done really well in terms of a lower classification score, not very many or not very recent rule violations, that all to me added up to the fact that you might be someone that was worth seeing about having this kind of relief. So Andrea, I don't know if you want to add anything from your perspective at this stage before we let David introduce himself a little bit more.
No, I'll just let David tell his story and I can add anything on the end. Go ahead, David, tell them, who you are and about this process.
Yes, thank you for having me today. Nice meeting everybody. My name is David Harbans. I'm from Fiji. I'm half Punjabi, and I've lived in California all my life. I was a very broken, hurt, in pain, downward spiral kind of guy. And I went to prison in 1994 for 107 years. I did close to 28. It was 27 and some change. I got out June 15th. It's been 92 days. And if it wasn't for this PIR, the prosecutor initiated resentencing, if it wasn't for Andrea, Crider, and Caleb Webster, I'd be missing another one of my child's birthday, which is tonight, and I'm taking them to Tommy T's, thanks to all y'all. And back to what led to going to prison was anger, pain, downward spiral. I was an addict, a heroin addict, and I was in and out of jail, but I had never been to prison. And the district attorney's office finally put the hammer down on me, hit me with the 3 strikes law. And I didn't think I was going to be eligible for the 3 strikes law. Neither did my attorney, because I had never been to prison. But sure enough, I got 4 life sentences plus 7, all ran consecutive. And there I went. And the first 14 years of my incarceration was more boo-boo. The same stuff I was doing out here, I was doing in there. They sent me to high desert, level 4 yards, Salinas Valley, New Folsom, and just more trouble in and out, not learning anything, lockdowns, riots. And it wasn't until the last 14 years, they shifted me to a medical facility for other reasons that I'm not going to speak on because it's my health. And I thought when I went to prison, I thought all prisons were level 4s, 180, shoot, kick out yards, lockdown, stabbings, killings. When I got to Vacaville, I was like, what is this? This is nice. What do you mean I can go to a group? What kind of a group? And there's many groups. You can pick whatever group you want to go to. I can go to school here. I can go learn vocation here. I can get certified in this. I can get certified in that. Wow. And that's when my last 14 years of incarceration turned into rehabilitation, sobriety, learning, evolving, personal growth, learning how to manage my anger, learning the 12 steps. And when I started this 14 years ago, I had no light at the end of the tunnel. I was still going to die in prison, and I made peace with dying in prison. I did this to myself. Nobody did this to me, even though I was abused every which way possible, abandoned, hurt, blah, blah, blah. At the end of the day, nobody made me commit robbery. Nobody held a gun to my head and said, you have to commit a crime, and I went to prison. Those were my bad decisions. So I learned how to talk. I learned how to develop my voice. I learned how to be a facilitator. My new way of getting high is helping other people. maybe not getting out of prison, but helping them learn how to manage their anger, the criminal thinking, the domestic violence, the gazillion other groups that they have that are not voluntary, but they are voluntary. They should be mandatory, in my opinion. I think everybody should have to take these classes, determinate and indeterminate. Anyway, I can go on and on about this. I know I'm only on this for a few minutes. So I just wanted to say thank you to everybody, especially Andrea and Caleb. And I hope you guys continue to get people out. And I hope little minor infractions like let's just say hypothetically I came from High Desert last month and I'm eligible to go to the board, and my recent write-up stems from High Desert being somewhere where my life would be in danger if I didn't do what I did. So I get a write-up for it. I come to a nice place where I can evolve and have personal growth. I go to the board and I get a denial because of a recent write-up. I would like people to look at where that write-up came from. Could it have been avoided? And at a facility like Vacaville, yes, all write-ups can be avoided. And a facility like High Desert, Salinas Valley, Level 4, some write-ups cannot be avoided because they manipulate you. They talk you into doing this. And if you don't do it, you're going to get stabbed. You're going to get removed off the yard. So there's a bigger picture to all this. And I just hope everybody looks at these little infractions that were 3 to 5 years ago. Where was this person 3 to 5 years ago? Where was his maturity level? Where was his sobriety level? Where was the personal growth? Anyway, like I said, I could go on and on about this. I'm gonna keep it short. I just want to say thank you for getting me out today. My family says thank you. And any way I can give back and contribute, I would love to come back. Thank you.
You're awesome, David. And thank you so much for coming and sharing your story. I wanted to make sure to invite him to do so because he was, like he said, it's healing for him to share. I never want someone to, have to do this if they don't want to. And I've just been thankful for you to share the human face and aspect of this work. And David he's so kind, like giving Caleb and I credit for him coming home, but really it was David and all of the work that he did while he was incarcerated that brought him home. And our office just helps put it in a pretty bow and hand it over to the DA who takes that deep dive into it too. So I'm so happy that you came and shared your story.
And I just want to add really quick to David that it was really cool. We got to meet before this, and I know that you got home in time for Father's Day, which was a pretty cool opportunity for you to get to spend that time with your family. And it was really neat for me to get to hear that story, and helps me as I continue to work. Hearing from you really helps me to do my job better. So thank you. I know that you've got still some challenges ahead, and I wish you luck, and I hope that we can keep reconnecting down the road and see how you're doing. So thanks for taking the time to be here.
Yeah, and I will talk a little bit about the reentry process later in this presentation as well. So I'll let Caleb go over what they are looking for in terms of when they're making these considerations.
Great. So being mindful of time, we do want to know sort of about some of the things in the past. So what got a person to the stage where they received such a lengthy sentence, and then what happened during the actual offense, because there are some of them, some of the offenses that it's from our office's perspective, that we are less troubled by a lengthy sentence now at this stage than we are on others. So for instance, David's sentence of 107 years to life, and he hadn't gone to prison before, that seems way out of line with what people are receiving today. But there are some people who have received other lengthy life sentences that are much more commensurate with what people are receiving today for that, and understanding that some of the people who are viewing this might have very different views on incarceration, but just from our office's perspective, that's one of the things that we consider. We do want to look at the age and the time of the offense, at the time of the offense, and the person's current age, some of their criminal history. And then we're looking at some of the things more recent. What's this person's trajectory like recently? So with David's case, we saw that there had been some previous write-ups and things that he was describing, but that his recent history showed that he had, for various reasons, that he was in a place where we thought that when he was released, that he would do well in the community and had absorbed some of the programming. And so we want to look at why did this person, if they have received prior denials by the Board of Parole, what were those reasons, and have they addressed those factors? And then we want to be assured that if the person is resentenced, that there is a good plan in place for that person. It doesn't always need to be a bunch of family support. In fact, we've learned that sometimes that can be a hindrance for some people, depending on what their systems and their structures were and what led to some of the things that occurred earlier on. But we do want to make sure that there's a good plan in place, and that Andrea has been very important at generating that for us and helping ease our worries about that kind of thing. So I'll just say at this stage, we still don't see someone's face like David's, but at this point, our file that I'm putting together, it starts to grow. It starts to have some of the information about some of the stuff that happened previously, more recent things. I will have looked at the C file, which is hundreds of pages. So I'm getting a lot of information by this point.
And so because this is a CLE, I'm going to briefly go over the law, which was previously 1170D1, then 1170.03, and now has been recodified at 1172.1 in the penal code. A lot of people still say 1170D as sort of a slang for this, but with the enactment of this law, the legislator created specific procedures for courts to employ when they are invited by an executive branch office like the district attorneys or CDCR to recall a sentence. As of 2022, the receiving court's required to appoint counsel for the person. So while I'm not technically appointed counsel in the consideration process, I do assist in creating those resentencing packets for the district attorney to consider. And I do try to advocate for the person in that process. But once the recall or the recommendation for the recall actually takes place, there is a right to counsel. The court, if there's some kind of where it can't come to an agreement on a stipulated resentence, which is typically our process. We've been able to stipulate to resentencing in most cases. We're seeing credit for time served anyway. But if there is some type of non-agreement, for example, the court is to set a status hearing, and they do have a right to a hearing where the court must presume that the sentence should be recalled and that they would be given a lesser sentence unless the person is found as an unreasonable risk to public safety and that they would commit a super strike offense. So for anyone who does clean slate work on here, that's a similar standard to the Prop 47 and mental health diversion. And but like I said, typically within our process of PIR, once the district attorney recommends the recall, our office has been able to come to a stipulated agreement and not have a hearing. And so that brings me to the step one, which is the actual recommendation for recall. And the law allows for the court to consider both post-conviction factors, and they're required to consider pre-conviction factors such as psychological, physical, or childhood trauma. And so often that requires looking back in these old cases about what type of mitigating circumstances were presented the time of the trial or the plea, which typically, given these are 20 years old and we have a very different understanding of mental health and childhood trauma, there isn't a lot in the old file. So we will help the incarcerated person and their support people typically develop some type of social history that will address these pre-conviction factors that are now considered mitigators. And the court is also required to apply any changes in law that will reduce sentences or provide for judicial discretion. And it says as to eliminate the disparity of sentencing and to promote uniformity. And so once a recall takes place, all ameliorative laws do apply. So, gun enhancements that were previously not discretionary, or 5-year prison prior enhancements that are now discretionary. Those are things that, while a case may have been final and therefore they don't retroactively apply in those cases, once the case is recalled, they will apply as well. So typically when we're coming to our stipulated sentence, that's kind of taken into consideration in terms of what we're trying to come to in an agreement as well. Some of the pre-conviction factors that are important to explore, I wanted to talk about how to sort of work up a case, and I did in the materials provide a packet done for the people that explains how to write a lot of these materials, and it explains how to kind of work up a case as well and create a resentencing packet. Those will be provided after the training, I assume. But it is important, like I said, to gather social history information. I say Franklin mitigation, that's the youthful offender law. And not everyone who is being considered was necessarily a youthful offender when they committed their offense, but those factors and working them up, it's similar in that respect. And important to kind of explore adverse childhood experiences, and if there was mental health issues at the time, or if drugs were connected to the offense, because those do explain the reasoning why the person might have gotten into that situation in the first place. And it does mitigate and help us humanize and understand like why people might make mistakes in their past. And then it's important to explore the post-conviction factors as well. Some Caleb went over on the other slide, but in the materials, I also have provided a central file authorization. So if anyone from the Participatory Defense Hub is on this webinar, or any families of incarcerated loved ones, that is how you can get, if you have your incarcerated person sign that form, that's how you can work on trying to get the C file so that you can review it. I also included, I believe, the medical authorization for anyone who might have some specific medical things that you wanted to get out of their files to present. For example, if someone is significantly incapacitated physically, that does reduce their risk for recidivism. So it's something that we would want the district attorney to know, for example, if they were wheelchair bound or had some type of mobility issue. And then it's really important to have reentry plans. And that's something that our office works directly with both the incarcerated person and their loved ones to do, specifically housing. Currently, the district attorney does require everyone to do a 2-year parole credit waiver in order to benefit from their recommendations so that they can parole into housing. Parole will pay for the housing. I've had, and then it's also important to develop a relapse prevention plan. I often have people, tell me that drugs wasn't an underlying issue, and it hasn't been. And you can see from their record it hasn't. But I think that relapse prevention can go beyond even just substance abuse disorder. You can have either mental health or criminal thinking. It's really important to recognize like what your triggers are and what coping skills that you have, and actually put those in writing, because the stress of reentry can be real, as David knows. And it is a good way to show that you are prepared to address those stressful situations, whether or not it's something that is related to substance abuse or mental health. And then I always like to try to get families to give letters of support, specifically addressing if they knew who the person was at the time, what they know might have led to that offense, how they've seen them change, like, and real life examples of that. For example, the way they might be speaking on the phone to the person, they're just can tell there's been such a change from the time they were originally incarcerated to now, because they've gotten involved in all of these groups and they've done all of these things. Typically, loved ones know those things. And then I like the people to often also say how they can support that person in their reentry process, whether that's financially, spiritually, transportation, staying sober, housing. I think that that's good to put into the letter. And then finally, if there is a parole denial, such as in David's case, it's pretty easy to get the transcript. And if anyone needs the email address, I don't think I included that, but I can give it to you. It is public record. And just to go over the reasoning and make sure that the person who's incarcerated understands that too, because I always tell them, even if you don't get through prosecutorial initiated resentencing, working up a case for this and putting it together will empower you to do better at the next board hearing. So I always like to, use a lot of these same materials to help the person have more success at their next board and really understand like what it was. If they haven't done a petition to advance their next board after a denial, then they might want to wait until after we've created all of the resentencing packets and potentially apply if they have that ability for a petition to advance parole, because it does look better. As in David's case, this is what he did. He applied for a petition to advance parole and it was granted. So on paper, what that shows the district attorney is that he has addressed the things that were the underlying reason for the denial, because that's how BPH decides to advance someone's parole. And then the next step is to get resentenced. And like I said, in practice, we are typically coming to a stipulated sentence, but there is a right to a resentencing hearing. Again, all new laws apply. And this is copy paste verbatim from the statute, but as you can see, it does contemplate for a stipulated sentence and the ability to not have a hearing. And we have the ability to even change the underlying conviction on agreement of both the parties to a lesser included offense, which can actually set someone up for an easier reentry, potentially, given what the conviction is, since there are, 75 collateral consequences of criminal convictions upon reentry.
So this is the motion, the stipulation and proposed order, which became an effective order that we filed for David's case. So his 107-year to life sentence was reduced to a 23-year credit for time served determinate sentence. He did waive enough credits so that he could be placed on parole for 2 years. So he's currently on parole and he's, as you all can see, he's doing fantastic. David, do you want to fill them in? Are you working, and how has parole been going so far? Oh, you're on mute.
You're on mute, David. Just press the space bar. Another one of the new things about reentry is learning how to use computers and phones. And I remember when David first came back, he got a Galaxy phone and was struggling with swiping to answer. But there you go. You're unmuted. Go ahead.
Okay. Sorry about that. I'm still learning technology.
So yeah, so David, how has do you have a job? How's parole going, and how's everything been so far on your 90 some days?
Pro's going really good. On my 3rd month of release. I'm on my 4th, possibly 5th parole agent. I worked for King's Pools, digging holes, breaking concrete, construction work for the first. Well, for the first week, I did not work. That was all family. The second week, I got the job. I worked for 9 weeks. And then right after that, I got a job at Tesla. So I'm working at Tesla doing 12-hour shifts for 4 days. My parole agents, all of them, all 4 or 5 of them that I've had, they're all very happy. They're pleased. They're impressed. They're shocked that I got a job at Tesla. I haven't given them any dirty UA tests.
Okay.
I've completed everything they wanted me to complete, except for the substance abuse class, which is almost done. I just need a certificate. And
That's awesome, David. We're so happy that you've been doing well. And I know that, like Caleb said, there's going to still be challenges ahead.
Yeah.
So we wanted to make sure that we went through the protocol for referring cases to us. Currently, we're going to have any referrals come through my office to be able to do a initial review. Here is the email address that we provided. We ask that you send all of the materials that you have to us so that we can have the best everything in front of us to be able to look at, what else we might need. We will evaluate the case, do a financial eligibility screening and conflict screening, make sure the case meets their current criteria or has some other edge to it that might make it something they'd want to consider outside of it. And we will engage with the incarcerated person and also work with the original counsel and or whoever it is that is referring the case to us for any other needs that we might have. For example, I might be like, hey, I think we could really use more of a social history workup for this person, or we really need a relapse prevention plan. And that's something that I'm hoping we can partner with the referring person or whoever the incarcerated person wants to designate as their main support person if they have it. A lot of people may choose to work with the Participatory Defense Network, which I saw Oscar is on here, which is awesome. He does that work. And we have Reuniting Families here in Contra Costa who's been helping us. Oscar just put the email address and phone number in the chat. So please take advantage of that. They can help empower families to work up these cases and create these resentencing packets, and they do an amazing job. Not everyone has support people on the outside. That's sadly just the reality of mass incarceration's grasp on families. But if that is the case, it doesn't mean that we wouldn't take a referral. It's just good to know those things so that we can make sure that we're putting in the extra effort to support that person if they don't have outside community support. And then we'll work directly with Caleb's office with the consideration process, of course, informing original counsel and the person who referred the case to us. There is no timeline on, when the district attorney has to make a decision. Currently, our plan is we have a shared drive where I will drop the resentencing packets into, and when those get considered is something that we're still working out because, as Caleb said, the criteria is subject to change as the review process continues. And I think that that's something we both foresee happening. But we are certainly trying to stay within the cases that are incredibly compelling at this time. I like to think of this project as sort of behavior change. I think once, the committee starts seeing the lower hanging fruit, if you might call it, cases, and if some of those don't make it through, they'll want to look back at those once they start seeing that, there's only so many people in CDCR who do fall within that criteria, but there certainly are other people who are low risk to public safety that they will want to eventually consider in the future. So my point is that there isn't a timeline, unfortunately, and it's really important to manage your loved ones and the incarcerated person's expectations in that process. We are trying to, or at least our office is trying to prioritize if there is, an upcoming parole hearing to get the case looked at potentially before that. But that doesn't always happen. So it's just important for them to know that. And then if the DA agrees, they will recommend the recall to the court. I said it's typically followed by a stipulated resentence. We haven't had the need to have a hearing at this point. And then once the person is released, we do have a reentry coordinator in our office who does follow up. And if they are paroled to Contra Costa, we work closely with the Reentry Success Center in Richmond to get them wraparound reentry services. So you can see.
Andrea,
Yes.
one last thing, if you can go back, I kind of skipped over it before, but the way that our office reviews the cases is not, Andrew's working things up, I'm working things up, but it's not a decision made by me solely. And so we have a committee that hears sort of a summary or here's a presentation, and then there might be some concerns that various committee members raise. We try to answer those as best we can, and then the committee makes a decision ultimately at the end of this. So in David's case, the committee passed him through for relief, and there have been others who there's been various concerns that have been raised that the person doesn't get passed through. But as I've mentioned before, we have done about 10 so far, and I know Andrea and I are both committed to the work and hoping that we can continue to do some good things and have people like David come back home, come back to the communities.
Yeah, and so far, the majority of the people, since I've been in January, that we have presented do pass the committee. The people that don't, though, there is no bar for reconsideration. Again, though, it's not, we can't give a timeline on when and if they will be considered, but that resentencing packet remains, in that file, and we can update it periodically. If the loved one and the support person is still working and doing things, we can continue to add to that resentencing packet and have it reconsidered at a future date if warranted. And so we just want to thank you so much for coming. We both left our email addresses if anyone had any specific questions for us. This is a photo of Christopher Hales, who was one of the first people in this county that got resentenced after serving 25 years on an 89-year sentence when he was just 21 years old. So it's really exciting and amazing to see these people come home from prison. And I just thank you all for coming. And Caleb, did you want to say anything else? Otherwise, David, also thank you so much for coming and sharing your story too.
Thank you, David. I do see that there are 2 pending questions, one in the chat and one in the Q&A. So the chat, there's a question of, is there an explanation given to the person if they get a denial? For a few reasons, our office doesn't send a detailed letter of the basis for the denial. In part, we have concerns about communicating directly with someone who may be eligible for relief in other avenues or who may be represented in other avenues. What I'm trying to improve in our process is when someone goes through committee review and the committee does not pass them through, trying to pass that information on to Andrea or the attorney that is assisting that person. And that way they have some information that they can use, and it's probably going to be helpful for them if they have a parole board hearing, because some of those concerns are probably going to be some similar. So we're trying to improve that process. And then the question and answer on the question in the Q&A, Are there benefits to people who are no longer incarcerated in applying, such as lowering or removing them from tiered registration or helping them qualify for professional licenses? Typically, well, so far we haven't considered anyone who is not currently incarcerated. But if someone comes to mind that you have a concern about, you can definitely reach out to Andrea. You could also reach out to me. It may be that the circumstances of that individual do warrant us using this particular avenue for reconsidering the case. If it's not something where other types of post-conviction relief might be available. So to date, no. What the question of whether there's any benefits, that's a little bit on you or on the attorneys to kind of assess that. And Andrea and I think, are both happy to be resources and collaborative partners in figuring some of that out.
Yes, and I have had some inquiries that about helping with occupational licensing. And I do think that it can be an avenue for things like that. But we do ask that you go through our clean slate unit first to seek expungement or other remedies that might exist. And once that is done, then certainly I think it's a discussion that we can have with the district attorney's office.
Okay,
Are there any other questions?
that looks like it. I know it's after 1, so thank you all for your time, and it was really nice to get to share some of this with all of you.
Yes, and thank you again so much, David.
Yeah, thank you so much for both to both our presenters and to David for sharing a very real look at what this looks like in the lives that it changes. If anybody has any questions, concerns, etc., obviously keep an eye out for all of the materials and feel free to contact me as well as our presenters.
Thank you.
Thank you, Andrea and Caleb and my puppy. Thank you, everyone, for participating. Thank you, David. Thank you, Ashley.
Thank you.
Sorry.